Hello and welcome to the sixth installment of Weltman's What's on Tap series. We received such good responses from our first 5 episodes that we thought we would keep them rolling along and add another series for you all to watch. So we thank you very much for your support and continued viewing of these episodes. And for those of you for the first time that are here, welcome. If you want to watch prior episodes and get an idea of what this series is about, they are available on our Weltman website. As was the case before, if you have any questions during the course of this episode, feel free to submit them, and we will either answer them during the course of the episode or we will respond as soon as possible, typically within 24 hours to get you an answer to those questions. As was the case with prior episodes, each episode will discuss a beer. In this case, I have a beer by Funk Brewery.
You're bringing the funk?
Bringing the noise, bringing the funk. This brewery is located in Emmaus, Pennsylvania. I've been there several times myself. They have a giant screen. They have a great area set up to watch games. They have a food truck typically, which is very good. This one is called Still Holding, You're My Boy Blue, which is a reference to one of the finest comedies of the early 2000s, Old School. So I had this the other night. It's a very good Imperial IPA.
I think that comedy is before Cam's day, right? Were you even born around then?
I was, unfortunately, yes, I was around here for that.
But barely, barely. But Funk is a great place for family, friends, to just hang out, enjoy a beer. Emmaus is a nice little town. There's a few other breweries in town, as well as a great beer store up the road. As far as who we're here with, I'm Scott Best. I'm an attorney out of our Philadelphia office, licensed in Pennsylvania and New Jersey. I oversee our New Jersey practice. I'm also here with Mike Dougherty. He's a shareholder with the firm. And finally, I'm here with Deane, who also works out of our Philly office, is licensed in Pennsylvania and New Jersey, and is also the resident bankruptcy expert for our office. This session is a follow-up to one of the earlier sessions that we had. I believe was our first episode with regard to replevins. This is a follow-up of what would happen once you get the car back. I don't know about you, but on the lending side, but on our side, we've seen a tremendous increase in volume of replevins over the last several months. They're keeping us quite busy. It's no secret that delinquency rates are much higher than they've been on vehicles. There's issues with valuations of vehicles, all of which creates a situation that causes the need to move forward with replevins, and then the question becomes, what do you do once you have the car? This episode will discuss the required notices that you have to send, penalties that there may be for failing to send. Once you do sell the vehicle, what to do with the deficiency balance, as well as the effect of bankruptcy on that process. That all having been said, the question then becomes, what, as the lender, do you need to do once you've recovered the car, either through replevin or if someone just returns the vehicle to you? In that case, there are 2 notices that have to be sent. First, you have to send the notice of intent to sell, or also known as a notice of repossession. The titling changes state by state, but the idea is the same. And then that notice advises the borrower that you have the car, what they have to do to recover the car, what their options are, etc. And then the second notice is once the car sells, you have to send a notice of deficiency or surplus. In almost all cases, it's going to be a deficiency. There was a brief time where there were some surpluses coming in, but not very often. So Mike, as I indicated initially, there are 2 notices that have to be sent. One is the notice of intent to sell or notice of repossession. Are there specific items that have to be included in those in that notice?
Well, Scott, absolutely. So before talking about that, so within the notice of intent to sell, you're absolutely right. This is probably one of the more timely topics we're dealing with right now based upon the number of delinquencies out there and actually repossessions that have occurred. So we stress upon you folks out there that the notice of intent to sell and the deficiency notice, which we're going to be talking about, are things that you really want your team to be looking at, make sure they're in compliance. With that in mind, the notice of intent to sell. In most states, they're guided by the Uniform Commercial Code, UCC, or your state's motor vehicle finance statute. So generally, that notice of intent to sell is going to incorporate one or both of those elements from those statutes into the notice. Now, why is that important? Well, if you're a state that just has a UCC notice of intent to sell, if you follow the guidelines within that UCC notice, you get a safe harbor. And what that means is if you do it exactly as the UCC says and send the notice that way, you're covered. You don't have to worry about a lawsuit coming your way if you follow that. Now, what you're going to see is a lot of states also have additions to that UCC, which is the motor vehicle statutes. So what you need to do is incorporate that language as well. And what you're going to see is even within most of those states, you're going to have a similar type notice, a form notice, that if you incorporate that as well, that will also provide a safe harbor to you. So it's very important when you're looking at those two notices, those two statutes, that you're properly incorporating them and you're getting the benefit of that safe harbor. So with that in mind, so what's in these notices? As kind of you talked about, Scott, there's going to be information concerning the balance due on the loan, rights to redeem, rights to reinstate. So all these things are set forth in the UCC and they're set forth in the statute. A couple things I want to point out based upon what we're seeing in our time. So one of the things we're really seeing, sometimes people forget, is whether it's the UCC or oftentimes your state statute, you talk about where the vehicle is going to be sold. And everyone talks about the date and place. Well, most of these statutes also say you need to know the time. And that's something that is often not put in there. So we recommend to you guys out there, make sure when you look at that notice, you have the time listed as well. That's extremely important. And then another area where we're seeing some litigation happen is concerning the time when that vehicle is being sold. So most states will have maybe 10 days, 14 days, 15 days, whatever it might be. And they'll put in that notice, we're going to sell it within these 15 days. The letter is dated January the 1st. Well, what happens is that letter is prepared on January the 1st. It might not be mailed to January the 2nd. So what you're seeing here is there's a bunch of those aggressive consumer attorneys out there. I think a lot of us out there know all about them. And they're filing these suits saying, well, wait a minute, you told us it was 15 days, but now we know that you mailed it a day later. You didn't give us that 15 days. So one of the things we're recommending people to do is, hey, if that statutory notice says 15 days, sell the vehicle on day 16, sell it on day 17. No need to jump on that exact day. Give yourself that little bit of wiggle room, and I think that's going to go a very long way to make sure things looking good there. So with Scott, I mean, that's kind of the basics of the notice of intent to sell. Mm-hmm. I think also within that notice, Cam, I think there's information concerning that personal property that's there. So can you tell us a little bit about the personal property and how you handle the items in that vehicle?
Of course. So as Mike mentioned, all notices are required to advise the consumer or the borrower that they have a right to reclaim any personal property left in the vehicle. Generally speaking, in most jurisdictions, that consumer has a period of 30 days to recover the property following the date of that notice that you were just talking about. So during that period of time, it's very important for the lenders to ensure that property is being stored in a safe place and to prevent any sort of unauthorized disposition of the property. Again, you generally need to provide 30 days. If the consumer makes no efforts to recover the property, at that point you can generally dispose of it. In some cases that might just be throwing it away, but it's always important to check with your specific state statutes if there's any specific directions that statute provides on how to dispose of unclaimed personal property. More often than not, it depends on the type of personal property we're talking about and if it has any sort of substantial value. Now, for purposes of storing it, you are permitted to charge storage fees related to the personal property. There's no bright line rule in terms of how much you can charge. Generally, my advice to our clients is to charge essentially the cost of storage if you're able to determine what that is. You just don't want to find yourself in a situation where you're charging any sort of what a consumer might consider unreasonable storage fee, because that's just another path for the consumer to engage in litigation following the repossession of the vehicle. And now the last point I want to touch on here is really what personal property is. So generally speaking, we're talking about small items left inside the cab of the vehicle or maybe the truck bed, tools, things of that nature. But we're not talking about fixtures. And what I mean by fixtures are things that have been permanently added to the vehicle, such as modifications to the engine or modifications to the body of the vehicle. Those things, once they become a part of the vehicle can be disposed of as is. You don't need to worry about removing aftermarket rims or anything like that at that point once you have possession of the vehicle. And Scott and I, we were actually talking about an example he came across recently that was pretty interesting, where I believe it was a tow truck. You indicated that
It was a tow truck that ironically had been repossessed because the tow truck company had stopped paying on it, and there were some items of a business nature that were in the cab of the truck, and they wanted also things that had been added to the truck for the purpose of their towing business, and the argument was over whether or not they could recover items that had been attached as a fixture to the truck versus keys and other things that were left in the truck. Eventually it got worked out. I think they were able to come up with a loan to pay it, so it didn't become an issue, but there was some argument, and the situation developed over whether or not certain items were fixtures versus personal property. And also, when you mentioned storage fees, I just wanted to make sure that it's important to know your local state statute for that. Some states do allow you to charge, some states do not allow you to charge storage fees for personal property. So that is, I just encourage everyone to refer to your state statute before making a decision on how much to charge, because I don't want someone to get jammed up thinking they can charge something and they don't.
Good advice.
Once you get rid of the property, you then have the option to then sell the vehicle. Once you sell the vehicle, the next notice that you have to send, as I indicated at the beginning, was the notice of deficiency or surplus. 99% of the time, it's going to be a notice of deficiency for the balance remaining due on the contract after you sell the vehicle. Similar to what Mike was saying earlier, your local vehicle finance laws as well as the UCC are applicable as far as what you have to include. Similarly, most states don't have a set form that is required. You just have to have information that's required. I've seen forms that all look very different, but they all have the same information. That information includes the explanation and application of the sale proceeds, which reflects the outstanding balance due, the how much the vehicle sold for, other repossession related costs, which would include the repossession and replevin costs, storage fees as far as storing the vehicle depending on how long they may have it. Again, state specific as to whether or not you can charge those. Any repairs that might have been made that make the vehicle more marketable. Sometimes there's a lot of work that needs to be done. Lenders don't want to go through the process of repairing $40,000 worth of a truck that's not going to ever get that on the auction market, as well as attorney's fees related to the process of recovering the vehicle. If we have to file a replevin action, the lender is able to recover those fees.
So the attorney's fees are recoverable and should be noticed in that letter?
It should be noticed. It's also specific to your contract if it's in the default provision that the lender is entitled to attorney's fees.
Okay. Because that can be substantial over time, right? If you have a lot of vehicles being repossessed, I mean, to recover those attorney's fees can be significant recovery.
Yes, very much so, especially if it's something that's long and drawn out. If the defendant's side makes it a longer process, then the fees can certainly go up. It also will have, so then it'll have the balance remaining due, and then where to make your payment towards that balance. So, Mike, we discussed that these are all subject to UCC as well as your state finance laws. Or what are some of the penalties that may develop if you, not intentionally, but there's something wrong with the notice, something doesn't get sent, there's some problem along the way? What are some of the repercussions of failing to comply with the statute?
No, absolutely, Scott. I think sometime post-COVID, like I think everything in our world, everything changed post-COVID. I think the consumer attorneys all got together, and there must have been some huge conference somewhere where they talked about the different types of class actions they can file against credit unions related to failure to do something in one of these two notices. Was the I dotted properly? Was the T crossed? I think everyone who's listening right now and watching right now, you've either unfortunately been part of one of these class actions, or you know a credit union or an association that is aware of these class actions. So what you're seeing specifically is really they're the technical issues. For the most part, everyone's notice is hitting most of the marks. They're where they should be. But what these consumer attorneys are doing, they're holding everyone to their exact proofs. And by that I mean, let me give you an example. We talked a little bit about the 15-day notice, if your state has a 15-day notice. Well, when I was talking about that, I wasn't talking about that based upon some sort of hypothetical. That actually is a class action going on right now. And the same thing, the letter said 15 days, and they sold it on the 15th day. So what happened was that consumer's attorney found out that they weren't being mailed till a day or two later. Lo and behold, now you got a class action lawsuit. And at the end of the day, the language in your letter says 15 days, and if you sold it on 15 but it wasn't mailed till the day after, unfortunately you have a problem. So that's why when we talk about those types of things, make sure you give yourselves the leeway, because what are the penalties here? The penalties are pretty significant, especially when you're talking about a class action. You're talking about statutory damages, and more importantly, you're talking about the attorney's fees for these types of actions. And that's where these attorneys...
That's what they're looking for.
Absolutely. They're all looking for that, because at the end of the day, they might get their client $1,000 for a piece of statutory damage, but they might walk away easily with 6 figures in attorney's fees. So that's what we need to keep in mind. So those types of examples. There's examples related to if you're then going to file suit after deficiency is filed, but you're charging interest, you needed to mention that in the letter. Some people forget to do that. We've seen class actions on that. We've seen class actions on not having the appropriate time when the letter was, the sale was going to happen. So all I ask you guys, what you really need to do, and I recommend this, once a year, take your letters. Whoever your counsel is, whether you have someone in-house, whether you use someone outside, we recommend Weltman. Stephanie Collier, highly recommend. She's our pro on that. Once a year, look at these letters. And realistically, once you get the letter set up the first time, the look every year is not going to take long. It's just, hey, has something changed? Is there something different? And the protections you guys will get for this will go a long ways. So Scott, with that in mind, let's get our folks protected. Let's do that. So now what happens? Let's say we've done everything right. We've sent the appropriate notice of intent. We sent the appropriate deficiency letter. How are we now going to recover on that amount that's due? What do we do then?
So if they're not voluntarily paying, then the option is to file suit against them. We do those very frequently where we're pursuing the deficiency balance. In that regard, there's certain things that you have to be conscious of, one of which is the statute of limitations. In some states, like New Jersey, the statute runs not when you sell it, not when you might recover it. It is when the last payment was made. The last payment date, and it has to be the last payment made by the consumer. In some states, the statute of limitations will vary based on a standard breach of contract versus a sale of goods, which might have a different statute. It does in New Jersey. It's 4 years for a sale of goods. It's 6 years for a contract.
Well, Scott, when we talk about the date of last payment, you've probably seen this, and so have you, Cam. Mm-hmm. Oftentimes, you might get a gap refund. You might get obviously, you'll get the sale of the vehicle proceeds. Oftentimes, unfortunately, folks within their systems, they use that as the system is set up that almost is considered a date of last payment, right?
Correct.
So you got to be careful about that, right?
Correct, yes, because you want to be able to differentiate for us when we're trying to determine if it's still in statute, as that is a defense that will have your case dismissed, that it's not a gap refund payment or some kind of other return to the lender of something that was paid in advance that's no longer getting used. That will throw your statute date off. Other items that we should consider in that regard, or that you should maintain, are your notices that you send, your notice of intent to sell, as well as your deficiency notice. Obviously, keep a copy of the contract that shows how your balance. Same thing with payment histories, how all of your payments were applied, because people will say that I paid, you didn't apply my payment correctly. We want to be able to show that. You also want to maintain your auction documents to be able to show, because coming into something that is known as commercial reasonableness, you want to be able to show that the process, that the certain number of bids, where was the bidding started, how did the bidding go? Because in a second I'll get into the defenses that we see regularly, and that's amongst the top ones. You want to maintain any bills related to the repossession, repair, and storage. Mentioned in your deficiency notice, you want to be able to provide those to the court in the event that they question, well, where's this fee and that fee coming from? You want to be able to definitively provide that proof. The other thing you want to maintain or attempt to maintain is debtor location information, so that when you do file, they might skip out of town on you. You want to be able to know. You don't want to sue them where they were 3 years ago, because they may or may not be there anymore.
Now, Scott, do you recommend when these notices are sent, some of them are required to be certified mail? Do you recommend keeping the certified mail notice, or how do you?
Correct.
What would you recommend there?
I would recommend to keep the certified mail return receipt. That way you can either show if it was unclaimed, or if it was refused, or if it was signed for. Ideally, that would be the most ideal situation. I know a lot of places, when it comes to court rules, it's that it's considered served if the regular mail doesn't come back. But I would still recommend maintaining all of your certified mail documentation.
Okay.
So we did have a question that did come in, that is, what happens if during this process you notice there's an issue with title, where the lien holder or the lender's name, for whatever reason, wasn't added correctly to the title? What is the mechanism to curing that? I know in New Jersey there's a form fee or a form that needs to be signed. You can submit that to correct the title. The problem with that is it requires the consumer who you just took the car from to be cooperative. Not always, not well. So the option then is you can file a declaratory action or declaratory action in the Chancery Division, have the court say the proper lien holder on this vehicle is Bank X, Credit Union Y. How does it? I don't handle this aspect of things in Pennsylvania, so how does it work in Pennsylvania?
Sure, I'll take that one, Scott. So this is something I've been coming across a lot recently. Specifically in Pennsylvania, we're running into this issue where some problem creates an issue where the lien holder cannot properly perfect their interest on the title, is the language we use. And when that happens, of course, this is an issue that gets discovered after a repossession takes place, and the lender is sitting on the vehicle, unable to actually dispose of it, though, because they don't have a clear title to transfer. So what we do is, similar to New Jersey, we at that point have to seek judicial action. Generally speaking, if there's already a case filed, for example, a replevin action that we talked about earlier against the consumer, you can then go right into that same lawsuit and file a motion to transfer invest title as the creditor. You do so by proving you have a valid security interest with your contract language that was signed at the outset of the loan, and generally speaking, at that point the debtor becomes unresponsive, but even if they do, they don't have much of a defense because of the contractual security interest that has been created. So it unfortunately can delay the process, maybe a couple of months depending on the county you're in Pennsylvania, and generally speaking, a similar course of action would have to be pursued in any jurisdiction where you don't have a perfected title interest. You have to then seek judicial action to effectuate that title interest, especially when you don't have a cooperative consumer who's willing to turn it over to you.
Thank you. So, as I mentioned before, there's defenses that are raised. We kind of see the same defenses raised in cases. If we do choose to pursue the deficiency, we see defenses raised. Those defenses can include wrongful repossession, where something during the course of the repossession was done improperly. Either the repo company breached the peace, they did something wrong in their process, there was an issue that the person was paying and then it wasn't getting applied correctly to the account, which then led to the car being repossessed, and only after the fact was it realized, but you had already disposed of the car. You can see a dispute as to the sale price, which would include a question as to commercial reasonableness, which is something we'll discuss further because it's kind of complicated. And if there's some issue as to the contract being misleading and something misleading to the consumer in the contract, all of these will end up with the court saying that you're not able to pursue the deficiency balance. So one issue that I've raised once or twice was the commercial reasonableness of the process. Cam, is the commercial reasonableness have to do with the value of the vehicle, or is it a question as to the process of selling the vehicle?
Sure, Scott. So I'm glad you bring this up. This is the most common defense that I run into in prosecuting these deficiency balance claims, is essentially the process of disposing of the vehicle after repossession. So in the majority of jurisdictions, the standard is called commercial reasonableness. And essentially, it is a reference to the process of disposing of the vehicle, not the price at which you sell the vehicle. So I know you both have seen this before too, but of course, no vehicle costs as much as it does the day you drive it off the dealership lot. And they immediately depreciate in value, except for a couple of years here recently where, for whatever reason, they went up. But putting those couple of years aside, everybody tends to know the reality is you pay more for a vehicle from a dealership than it will ever actually be worth in reality. As soon as you drive it off the lot, it is immediately depreciated in value. And over the course of a few months, that depreciation will continue to accrue. So just kind of following it through the normal course in this situation, the lender will take possession of the vehicle. They will dispose of that vehicle in a commercially reasonable manner, which I'll get into, but it more likely than not will be a public bidding auction. And of course, that is not the place to get the best, highest price for any sort of automobile. So the situation I run into a lot is a consumer or their attorney who will come into court and say, I paid $40,000 for this vehicle on January 1st. You sold it at auction 6 months later for $22,000. There's no way that that is the fair value of the vehicle, so you sold it for less than it was actually worth. Therefore, I'm not on the hook for the overall balance still owed on the contract. That is not what the court requires you to prove, is that you sold it for what the fair market value is. Instead, it is just the process of going about the sale. So generally speaking, what the courts look to show the sale was conducted in a commercially reasonable manner is that the method, manner, time, and place of the sale are reasonable. So just to expand on that a little bit more, it means that the vehicle was sold in a market for vehicles. So a lot of times we're talking about a public auction of several vehicles at a time and multiple bidders engaged in the process. It can also be done at a private auction or a private sale if there is sufficient marketing of the vehicle, if the lender took or engaged in efforts to actually ensure they're obtaining the highest possible price they may be able to get. And then the last thing I really want to point out here is that if there is a process within your particular region to engage in the sale of the vehicle that other dealerships or other lenders engage in, essentially following whatever that process is a good way to keep to ensure you are following what the court will determine is a commercially reasonable sale of the vehicle.
And we did have one last question that came in before we wrap this episode up, and it has to do with bankruptcy, which is Cam's area of expertise. So Cam, generally speaking, how does bankruptcy affect the process of either once the vehicle's been recovered or once the vehicle is sold?
Sure. So this is something that happens all the time. I will say it's a topic in and of itself, so I'm sure we'll have other webinar episodes coming out to explain in a lot more detail what to do when this situation comes up. And I know our firm produces other webinars that'll cover it as well. But generally speaking, when a bankruptcy gets filed, it kind of depends on where you're at in the process. So doesn't matter what chapter. If we're talking a consumer case, it could be either a Chapter 13 or a Chapter 7. But if you have not yet taken the vehicle and you get a notice that the consumer has filed a bankruptcy, you can't take the vehicle at that point. You have to then retain bankruptcy counsel and file a motion for relief from the automatic stay if the situation warrants to still be able to recover the vehicle. If you have already recovered the car but have not yet sold it, then once you get a notice of bankruptcy filing, you have to keep things where they are. You cannot proceed with the sale of the car until you've again file that motion for relief, show the bankruptcy court that you're entitled to relief from the automatic stay, and then can proceed with the disposition if your motion is granted. Now, a lot of times you're not required to immediately turn the vehicle over, but the debtor will want the car back. So often I saw when I was representing debtors, it was the repossession of a car that prompted that debtor to come in and actually file the bankruptcy petition. More often than not, they're then going to file a motion to turn over property to get the vehicle back so they can retain it and address the outstanding delinquency on the loan through their bankruptcy case. I, in my practice now representing creditors, tend to not advise them to contest those motions because the courts almost always will grant them and give the debtor an opportunity to sort out whatever the delinquency is with the auto loan.
So it sounds like it's a topic for a whole nother webinar, right?
Yes. Again, something we will cover in a lot more detail in other webinars in the future, as well as other attorneys in the firm who have spoken on the issue.
Closing with the bankruptcy, that wraps up this episode. We thank you. A thank you to those who are here and watching. For those of you who this is your first time, welcome. For those who are returning, we thank you again for coming back. After this episode is completed, if you still have any questions, please feel free to reach out to us, either through this webinar or directly to Cam, Mike, or myself, and we will respond to your questions. Also, please complete the questionnaire or survey after this episode. We do very much review and value that feedback. And if you like what we've done here so far, you can look at our past episodes as well as other webinars. We have Coffee with Casey. We have an Ask a Pro series. We have articles and other informational material that comes out very frequently on our website. With regard to this episode, we will be sending out a PowerPoint, as well as a copy of this episode will be available on our website for later viewing if you are so inclined. Our next episode of What's on Tap will be on April 17th, 2025. Episode will involve the handling of commercial loan defaults from workout to judgment, and it will cover how do we handle a commercial claim. So I thank you again, and
Now pass me the funk.